Everyone to go. How are you, sir? Good. Oh, that's what I was.
The July 18th special city council meeting in the city of Springfield is called to order. Please rise for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Clerk, if you please call the roll.
Alderman Redpath. Here. Alderwoman Simpson.
Here.
Alderwoman Turner. Here. Alderman Fulgenzi. Here. Alderman Proctor. Here. Alderwoman DeCenso.
Present.
Alderman McMiniman. Here. Alderwoman Connolly.
Present.
Alderman Donlin. Here. Alderman Hanauer. Here. Mayor Langfelder.
Here.
Mr. Mayor, a quorum is present.
Thank you. As a reminder, we're here for the election of Ward 2 aldermanic race. And just as a reminder, especially in being the capital city in Springfield, we are a nonpartisan government, and I think everybody holds true to that. And really what we want to make sure is the hearing officer had told us is, be consistent and apply the law justly and fairly, and most importantly, with the intent of the voters in mind. So we want to make sure that that happens, and hopefully we'll have a resolution sooner rather than later. So with that, I guess open it up for how should we proceed?
The current, you may recall, the parties and the hearing officer had made both recommendations, responses, and or questions to the parties and to the hearing officer. So this part now is really for continuing the debate or deliberation of the council.
Mr. Mayor.
Alderman Redpath.
Could you make sure that everybody silences their phones? The other night when we were here, we were interrupted on a couple of occasions, so if you would mind, please.
Mm-hmm. Yeah, if you take a moment to silence your cell phone or shut it off, we'd appreciate it. Alderman Hanauer.
I guess we need to kick this thing off. I'd like to make a motion that we accept the hearing officer's recommendation with the exception of the following. Section 2D entitled 11 Affidavits of Assisted Voters in Precinct 87. Challenges 87-26 through 87-36 should be counted 100% rather than apportioned. Section 3A entitled No ballots, no initials of election judge. Challenges 79-3, 79-4, and 79-6 should be counted. And Section 3D, 2 invalid affidavit of assisted voters in Precinct 3 and 75. Challenges 3-10 and 75-3 should be counted 100% rather than apportioned. 3-0. No, it's wrong. I think, and one thing to point out, in the judge's recommendations, there was a typo. It said 75-30. There was no 75-30. I think, or 030. I think it meant 75-03. I think you got a little quick on the trigger with the zero. So,
Mr. Alderman Hanauer, could you? I'm looking for my spreadsheet.
I can explain a little bit if you'd like.
Go through each one of those.
One at a time.
Should we get a second first?
Yeah, I need it before we can do anything.
I'll second.
Been seconded to discuss the recommendations for approval of the hearing officer's recommendations as signified by Alderman Hanauer. And seconded?
Yeah.
By, Alderwoman Conley. I guess, is there all in favor? Say aye.
Well, we got a discussion.
Discussion. He made a motion.
Okay.
And so there'd be discussion related to the motion.
Okay.
I'm willing to vote on it,
Alderman
and
Donlin.
hopefully we can get this early. So.
Thank you, Mr. Mayor. Ladies and gentlemen, this is one of those interesting moments in City Council history where we're doing something that isn't every day, and it's a little bit out of the ordinary, needless to say. Alderman Hanauer, earlier this week, we had discussion in this room about part of your recommendation, and that being the ballots that relate to that were initialed about 1 inch to an inch and a quarter to the right of the line at the top of the ballots. And I'm happy to see that your recommendation that you put forward in motion would allow for those to be included. Appreciate that. I think, I've been asked when I'm out and about in the community about, Jim, who you for? And, not to sound corny, but I said, I don't care. It's not about the candidates. It's about the voters. And, you said something to me on the phone about a week ago, and it really didn't hit home until after Tuesday night. You were talking about, Alderman Hanauer, your uncle, who is disabled, and you said, Jim, it just bothers me, these ballots that were done with the affidavits in the Mary Bryant home, that they're not being counted, meaning not included as a part of the recommendation. And I know this is a part of your motion this evening to include those items in the count, and to me that means it's about the voters. And that's really what this should be all about, and the heart of the matter that's before us tonight. What was the intent of the voters? Could there be a next step in this process? Yeah, if we ever got 6 votes in this room on whatever's before us. But a next step would be, the way I understand it, some type of a court challenge. And that we can't ever get to that point and put things to rest unless we do have 6 votes. And with an understanding that in the interest of the voters, I plan on supporting what you put forward this evening. And I appreciate your time and efforts that you put in for this. I've given it a lot of thought, and I think the voters that the 11 voters should be included, and the other ballots as well as a part of this. Thank you.
And Mayor, if I can follow up with that, just to give people an idea what this does, it basically takes the 3 ballots with that are off, the initials are off to the side, so you get those 3, and then it doesn't diminish or I guess it's called apportion the Mary Bryant home and the other 2 assisted voters. I did not include any ballots that did not have a judge's initial. Everyone in this portion, we can go back to some sort of to a person, because the initials they were on the right-hand side, we know we can go back to that. The people signed the affidavits, we can go back to those people. If they didn't have a initial on it, there's no one that we can go back to. So, and that's where we came up. And again, this was for the voters. To me, this is what the voters wanted, and that's why I put it forward. So thank you. Thank you for your comments.
Alderman McMiniman, did you
Yes,
have
I
something
did.
previous? Sorry.
I've done the math on this approach, and is it accurate and according to your calculation that this results in a tie vote?
I've done the same. I've asked Mr. Zirkle. I've asked him to make sure, and I'm going to. Jim, is that correct? We are at 464.
What I was going to say, what I would recommend we do is, it does appear to me, based on the judge's recommendations, that it results in a tie. But if the motion, if the council's determination is to act according to the motion, then what I was going to respectfully suggest is we take a couple of minute recess, because I do want to talk to the parties to make sure if everybody's in agreement, it is a tie. I don't want to be in a position where there's some disagreement, and if the decision of the council is to do that, then I would ask that maybe the parties and the recount hearing officer, we can caucus for one moment to make sure that everybody's in agreement of what the effect of the vote is.
So I can say I took Father Piser's math at SHG, or at Griffin, but that has nothing to do with this legal math that Judge Mealich did. It took me a few times and asked a few people, so I'm going to.
Piser's taught me too.
Mr. Mayor.
Alderwoman Conley, then Alderman Redpath.
Thank you very much, Mr. Mayor. I'd like to just take a minute also, if I could, to speak to the voters of Ward 2. I hope that, first of all, I want to thank you all for your patience. I want to thank you. This has been a very lengthy process, and I understand the strain and stresses. This is for the voters who took the time and duly did cast votes on April 2nd, and we're now in the middle of July. I hope you know that as we go into this, I'm obviously not a voter in Ward 2. I don't have a preference on the candidates in taking this action. For me, this is about being respectful of your votes, of your time and your energy and your patience with us and with this process. Our elections, we kind of come to learn, can be messy, but democracy is like that sometimes, and my vote today will be as much as possible to honor that process, to be respectful of that process, and to give you my best vote in what I hope reflects the interests of the voters. I will say I still have significant concerns about the statutory requirements of the affidavits that were not completed properly. To that end, I've already spoken with, I'm talking to Mr. Gray also, but I intend to go and volunteer in November of 2020 to be down at the Mary Bryant House and to ensure that I'm part of being a solution to this process. That's my proactive promise to you for next year. For right now, I want you to know that my vote is for you, for Ward 2, that we are one community in this city, and I take that very deeply to heart. So thank you very much.
Alderman Redpath.
You know, the most important thing is that we want every vote counted, and this body has done their best to make this as transparent a situation as we possibly can. A lot of us have been deliberating day and night. I know I have. But I still have some concerns about the Mary Bryant home ballots, and I'm going to tell you something. I've looked up the statute. There's a difference between substantial compliance and strict compliance. And when we're talking about substantial compliance, it means you have a little bit of leeway versus the strict compliance, which the state statute says that you have to have. Under the way the statute reads, it says where a voter is assisted in preparing their ballot by election judges without making an oath of affidavit, they are partially unable to prepare the votes and cannot be counted. The statute requires that affidavit be mandatory. So that's part of the statute. I'm going to ask counsel, Mr. Murphy, to come up here and explain the difference between the substantial compliance versus the strict compliance, because that's what those votes are all about. If the affidavits weren't filled out properly, the votes cannot be counted by state statute. Would you please step to the podium?
Thank you. Jim Morphew on behalf of the petitioner, Sean Gregory. So, Alderman, if I understand your question, you are inquiring as to the difference between strict compliance and substantial compliance. Well, first of all, you have to look at whether provisions of the election code are mandatory or directory. And unfortunately, there is no universal formula that can be used to make that determination. But basically, you look at the intention of the statute, the requirements of the statute, and whether it goes to the integrity of the election process. And let me use an example that might be recognizable to all of you as candidates, okay? We cite a case in our brief, the Serwinski case. And we cite that case to show the importance of the affidavits in the election process. And what happened in the Serwinski case is all of you completed a statement of candidacy when you filed your nominating petitions. And the candidate in Serwinski, everything was filled out correctly in the statement of candidacy. His name, his address, the office, and the document was notarized. But he did not sign the statement of candidacy. And the petitions were thrown out by the court because the oath was not activated by the absence of that signature. So that was deemed to be a mandatory requirement, and the consequence of not meeting that requirement was that candidate was off the ballot. And we would compare that to the signatures on these affidavits.
And there's, there was a discussion last Tuesday about, challenges 8726 through 34. There's both signatures, but, they're in the wrong place, okay? And our position is that that oath was not given because those signatures were in the wrong place. But apart from that, affidavits challenged under 87, 35, and 36, the person rendering assistance didn't sign that document at all. One oath is blank. The other oath, there's information about the voter on there, but there's no information about the person rendering assistance. So to the points that have been made with concerns about the affidavits, and whether that person assisting, a disabled or illiterate voter, is subject to any oath under the election code in those two challenges, nobody is. So so I hope I've answered your question.
You did, but I guess I'm getting down to the point that am I correct about the statute? Am I correct about my readings that it's mandatory that affidavit has to be filled out completely and also name the disability, have the address of the people? And although we know that where the Mary Bryant home is and that's where the voters are from, but is the statute clear and is there case law to support that?
Give me 1 second, Alderman. I'm going to find the statute. The section of the election code that governs this situation is section 17-4. And it's a fairly lengthy section, but the important provisions are any voter who declares upon oath properly witnessed and with his or her signature or mark affixed that he or she requires assistance to vote by reason of blindness, physical disability, or inability to read, write, or speak the English language shall, upon request, be assisted in marking his or her ballot by 2 judges of election from differing parties or by the person of their choice. And so it requires an oath, okay? Just like the court in Serwinski required an oath on the statement of candidacy. We think that oaths are mandatory requirements. Now, perhaps, a word or two missing in an oath, there's some case law out there where maybe the affidavit at the bottom of a petition sheet didn't have precisely the language that the statute requires. Sometimes the courts will look at that and say you substantially comply with the election code. But when you fail completely to give an oath that's required by the statute, and there's 2 oaths involved here. You've got the oath by the voter, and then you have the oath by the person assisting. And we think that those oaths are important. We think they're mandatory. In terms of case law, we cited 2 cases, the Chicho case and the Qualkenbush case. Now, as Mr. Yao pointed out yesterday or Tuesday, those cases interpret the absentee voter section of the election code, which is not this section, but basically the requirement is the same. The oath has to be given by the person seeking assistance. And in those cases, that requirement was held to be mandatory. And
when you have the affidavit that's partially filled out or not filled out but signed, it's not a good affidavit. Is that correct? Well,
I think there's, that's a question of fact, usually what information is missing. But what we have here is the person required to give the oath not signing under that oath. The person that gave assistance signed where the voter signed. And,
Is there room for substantial compliance there if they did not sign directly on the line? As if we had the initials they're not in the box, but an inch or 2 away. Is that the same situation?
Well, we would argue that it's not, because you have to look at the purpose of the requirement. The purpose of the oath is to say under oath you need assistance, and to say under oath that you're going to render assistance according to the directions of the voter. With the initials, first of all, there's nothing in the statute that requires the initials to be on the judge's initials line. The purpose of the initials is for the election judges to identify that that ballot was properly issued by that judge or by one of the judges in that precinct, so that it prevents fraud.
But that's no strict compliance on the initial side of that. On that initials, there
has to be a requirement before you could have strict compliance or substantial compliance. We're saying there is no requirement that it be on the line. So that's the difference.
Okay. So of all these, 11 ballots in the Mary Bryant home, were there, all 11 had some type of information left out. Is that correct?
Yes, they all do. The 8736 has a blank oath of assistance. There's no information at all on that one, just like there wasn't on 3-10, which Judge Mielek invalidated, and then 75-3. Those are all blank oaths of assistance. Basically, Alderman, 87-26 through 8734 are essentially the same. I mean, you have the person rendering assistance signing where the voter signs, and then you have the person that is the voter signing where the person rendering assistance is supposed to sign. So nobody took the proper oath. When you get to 8735, there is no name or signature of a person rendering assistance at all. So that's tantamount to a blank affidavit in terms of the person rendering assistance. 8736, it's completely blank.
Okay, thank you, Counsel.
Thank you.
My next question is directed to Corporation Counsel.
Before we do that, I don't know if the hearing officer or the other side would like to make any comments with regards to that matter.
I would, Judge. I just have a brief comment. I know what troubles a lot of you is the issue of the initials off to the side and not on the line. I thought someone was going to bring it up the other night, but they didn't. And so I'll bring it up tonight. Maybe it's because I'm a judge and I saw the worst in people, unfortunately, a lot. But what's the purpose for those initials? If they're there to show the ballot was properly issued, and it's not a hard requirement to put those right on the line. Why? Because when you take those ballots out of that feeder and that counter, if they're all marked on that line the same, nobody knows one ballot from another. They're all the same. You start putting initials on the side, you start putting numbers on the side, you start leaving one blank. How can these 3 votes with 3 on the side, but you can find the line on every other one of ballots? What that tells you is this, in my mind, is that people are marked, the election judge can mark a ballot by putting initial to the side and say, oh, when we take those out of the feeder to make sure everything's right, I can say, Redpath voted, he voted for Langfelder, not Edwards. I can look at his ballot. I know because I put the initials on the side on this one because I saw him come in. I mean, I left that one blank because I wanted to see what McMiniman did on his ballot. I don't want people looking over people's shoulders. You put it on the line, they're all the same. That's why the State Board of Elections says put them on the line. That's why our county clerk tells people put them on the line. Every ballot pulled out of that feeder is exactly the same then. There's no reason you can distinguish any ballot. Ms. Turner was talking about already how there was such dissension and problems about this election. I can see precinct committeemen saying when people came in, I'm going to write my initials to the side on these 3 because I want to know how they voted. Did they vote for Greg or they voted for... That's a problem you got when you start adding those votes. So my question, or what I'm saying to you is, when you're considering this, say, do we count them all or not? One or the other. I don't think you pick out 2 or 3 here and say, well, the numbers, that's okay. Or, I mean, they shouldn't be counted. Now they forgot to mark one. Oh, that's not good enough. Well, if it's good enough for 3 over there, then it should be good for all. So I think you should either count them all or don't count any of them.
Judge, I think your explanation, if I may.
I got a question on that.
Judge, then Alderman McMiniman, then Conley.
Judge, what you're saying there is like over here. So you're implying that that is a way to identify a voter to a ballot.
It can be. But I'm not saying that was done here. Right. I'm just saying it can be.
Right. My question to you is so I think if you're doing that, if you do it multiple times, then how are you going to be able to link that ballot to that voter if you're still, because they're all in the same
Joe
spot.
McMiniman and his wife and his son come in. I'm going to mark those 3 with my initials to the side.
But then how do you know which one's Joe's and which one's is?
Don't care. That's the 3 people that I'm concerned about how they voted in that election. Or there might be just one. I mean, I'm not saying that that's what happened here. What I'm saying is that's the way it can be done.
I'd like
You
to
could
hear
mark
from-
ballots. If you're marking them on the line on some people, why are you not marking them on all of them?
This is kind of a new one that we kind of brought. I'd like to hear from the two attorneys on this
First,
one.
any other questions?
No, I'm just saying, I'm just
Alderman
trying to
McMenamin.
point out that there are other ways to look at that, other than just to say, my God, the hearing officer is awful nitpicking, okay? I'm not being nitpicking. I'm thinking about these things, folks, when I make these recommendations. And that's a thought that came in my mind. I don't want somebody looking over somebody's shoulder. I don't want one of the things that was pointed out was that there was different ink on a ballot, and that distinguishes the ballot. And we might be able to tie that to a voter. We don't want to do that. I ruled that that's the voter did that, so let's count it. But you don't have to count that. You can throw that one out too. I mean, so what a point I'm getting at is there are a lot of issues involved and precedents set once you make these decisions.
Alderman
And I
McMenamin.
agree with everything you're saying. I understand you want to count all the votes. I just wanted to point that out, that is an issue, the way we do things, that it can be a way of marking ballots to check how somebody voted at a different
I think there's other questions pertaining to that.
Just a brief comment on that. I understand where the judge is going. He wants to protect the privacy of the ballot, and I understand that. But I can do my initials 5 different ways on that line too. So I just don't think that's something we should look at. I think we should go by the statute. The statute says put in judge's initials on the ballot, and that's the requirement. We don't have to create a different requirement than what the legislature gave to us, and that's what the standard we should use. And I would like to come back. I think Alderman Redpath is on the right track, talking about substantial compliance or non-substantial compliance and strict compliance. And I'd like some comments later on, because I think Alderman Redpath is going directly where I was planning to go on that.
Alderwoman Conley?
Thank you. And Judge Gann, I respect your concern for the privacy of the ballot. I'm going to come to you from a different kind of twisted background thinking. I walk into my polling place and someone's like, oh, I know Conley. I've seen the signs in her yard. I'm going to mark on the side of her ballot. And then they go in and they challenge the ballots in my precinct. And because my ballot got marked on the side, they can go ahead and throw that one out. I think the statute is clear that they need to be initialed. I understand your concerns with privacy, but I have a greater concern with allowing ballots to be discarded for a reason like that. So thank you again, though, for your consideration of this.
Alderman Redpath?
So my
to
next
this issue? Is this any other comments to this issue? The other side, do you want to respond to Attorney Morphew's comments, please?
If I could follow up just briefly on what the judge indicated. As you know, there are 3 categories of ballots that deal with the initial issue. You have the ones that lack any judge's initials, and then you have ballots that have numerals instead of a judge's initials, and then you have the PSH ones, okay, on the side, okay. It's been our position all along is to count all of those. If you really want to preserve the ballots and the voters, if you really want to make sure that the voters are heard in this matter, then all those ballots should be counted, and that's the way we have argued this, understanding court precedent along those lines indicating that initials are required, all right? But as the county clerk mentioned on Tuesday evening, and as we've argued in our briefs, allowing these initials just to be on the side opens the floodgates to potential fraud and misuse. And the judge talked about that, okay? The initialing requirement, if you're going to say it's mandatory, then you need to make sure that it is upheld. And that's with all the ballots. And yes, they need to be on the signature line here, where they are designated. Now, there's been some discussion about strict compliance versus substantial. With regards to that, first of all, even if a requirement is deemed mandatory, we have cited cases in our briefs saying even a mandatory requirement, If substantial compliance is met, that's sufficient, okay? And the Pullen Court, which is cited by both parties, Supreme Court, talks about how do you determine if this is a mandatory or a directory? And they indicated that where a statute in prescribing the duties of the election officials expressly states that the failure to act in the manner set out in the statute will void the ballot, that statute will generally be given a mandatory construction. All right. Now, the statute with relating to the affidavits at issue, the assisted voter affidavits, the statute does not say mandatory in here. Now, we're not saying that the election officials are to ignore it, obviously, but when you read Section 17-14, it doesn't use the word mandatory, and it certainly does not say that failure to follow it automatically voids the ballot. Okay. Now, I argued in our briefs and the other night that from our viewpoint, this is a directory requirement, okay, not mandatory. But even if it is considered mandatory by the council, then substantial compliance is sufficient here. And that we do have substantial compliance, and you have substantial information to know that actual disabled voters at the Mary Bryant House and 2 other precincts appeared. And their signatures do appear on there, yes, in the wrong places, okay? And at the Mary Bryant home, at least 9 out of the 10 have the signature of the person that assisted them, all right? They have the signatures of the election judges. And I don't know this, but I suspect that these particular voters had voted at that precinct for a long time, and those election officials knew who they were, obviously knew that they needed assistance in voting. And we had cited, and I mentioned about substantial compliance, the Siegel case, and in that case, the court indicated that an error does not necessarily result in the candidate's removal from the ballot, for example. All right. So I think we have to look at the substantial compliance here. Those affidavits are sufficient. We ask that you not disenfranchise. I also want to talk a minute, because we haven't talked about it too much, is one of the other challenges at issue here, and this is the damaged ballot. All right? The statute in this case is very clear that when you have a damaged ballot, it is to be labeled damaged ballot number 1.
Well, excuse me a second, but that's not part of this. That is not part of this, this motion. It's not part of the motion.
Well, we'll have to adhere to the motion. Is that true, Counselor? What's your opinion on this?
Right now, the subject before the council is a motion that is now pending. Your ability to address it does not waive the issue. So presently, the items that are before the council is what is specified within the motion.
And this argument is supposed to be a rebuttal about my question of substantial versus strict compliance.
On the affidavit, and that's what he did.
That's fine. I didn't mean any disrespect. I didn't know what the necessary rules of this were. So I appreciate that. The only thing I would add, just on my client's behalf, is that by the very nature of the motion that's being made, you're accepting the hearing officer's recommendation on the duplicate ballot issue. So,
and counsel, if I could follow up with a little bit, McCree versus Burnsmeyer, the Supreme Court ruling shows that this is what I got my reference that is mandatory. So you're welcome to this.
Well, I believe you'll see in our briefs that we distinguish McCree, that particular case sufficiently, and in that case, as I recall, there were no affidavits that were signed at all. The affidavits before you have signatures on them. That case did not.
But I'll read it again if you'd like. It says, where the voters were assisted in preparing their ballots by election judges without making oath of affidavit, they were they were physically unable to prepare the votes and cannot be counted. Statute requires an oath or an affidavit be mandatory. That's how it reads.
I appreciate that, your Alderman, but I guess I would go back in this as well. How do you know an oath wasn't given here? An oral oath, for example. because actually,
Isn't the burden of proof on us, them telling us that they did do it according to the way the statute reads, is that they say that oath has to be mandatorily put in?
well, once again, you have the election officials there that had the opportunity and obligation, if they felt that this person was not disabled and not entitled to vote, they had the right to challenge them. They obviously did not. We also know that the individuals reside at the Mary Bryant home, and by definition are blind.
That's an assumption. That's an assumption.
It's based in the evidence that's before you in the briefs, Your Honor. We have the documents in the briefs and the materials indicating that to be a resident of the Mary Bryant home, you have to be blind or have a significant visual impairment.
And is 100% of the people in the Mary Bryant home completely 100% blind?
I couldn't speak to that.
Just talking about the voters, those that voted. I guess to this point, I'd ask the hearing officer to come forward, and I just want some clarity on the affidavit itself. It's my understanding it serves two purposes. One is to, I think everybody, all the parties identified that, is to signify that the individual voting needs assistance.
Correct.
And then the second one is for the swearing that we're talking about. The swearing of that fact is that the individual making that oath swears to the fact that they filled out the ballot according to the individual voter.
Correct.
Thank you. And on all of those, I think the individual had signed. And I think talking about the affidavits, it's just like us. I'm swearing to that fact. If I filled out the form incorrectly, and this is my own opinion, if I filled out the form incorrectly and you come back the next day and said, well, you didn't fill it out right, and I'm going to make that same swearing in, that oath, I'm swearing to the fact of the vote. And so I think that's what happened is on the affidavits that came after the fact, I'm not sure when they came, that's what the individuals, those were the same individuals that helped with the assistance of the vote. And so they are swearing to the fact that they completed it according to the voters' wishes.
So how do you know that? What do you know what you're swearing to? You're swearing to something that's not even on the ballot. The affidavits were impartially filled out. So when you're writing on the line that you swear that this is accurate and true, there's nothing in there.
They're swearing to the ballot, that they completed the ballot per the wishes of the individual voter. Is that correct, Judge? The purpose of the affidavit?
That's the purpose.
Right.
I'm not sure that these folks are assisted correct.
Right.
My next question.
So is there any other questions on the affidavits? Alderman McMenamin.
I don't want to interrupt Alderman Redpath if you want to continue with their train of thought.
Appreciate it, Joe.
He's on a roll.
Man. So nice and polite.
A different issue to Corporation Counsel. I was told today that the Illinois Municipal Handbook states that if a quorum changes, that the votes required for passage drops and no longer need 6 votes. Can you clarify that, please?
Well, what you may be referring to is on for example, maybe a procedural vote, but for the city council to take formal action requires 6 votes. It's all aldermen holding office, whether or not they can vote or not, they're holding office. So in this case, there are 10 elected officials. Some may decline to vote, but they're part of the calculation. And with the mayor, so 11, and it requires 6 votes in order to take a formal legal action, for example, adopting an ordinance.
Okay, thank you.
So should we go through each motion you made, Alderman Hanauer, and with regards to your motion? I think we should, what you're trying to pass, I think it'd be,
I've got it all as one
everybody
motion.
would like a decision, I imagine, tonight. And so in order to get to that point, we probably should just go straight to the heart of it, discuss each one. If we want to vote on it collectively, we can, or just vote on them at each individual recommendation.
I would prefer to make it, to do it all as one.
Okay.
That's my motion. And
So do we need to refurbish? I guess, what's the council's preference? Do you want to go through each one, discuss each one at a time?
I thought that's just what we were doing.
Okay.
I could be wrong, but I thought that's what we were doing.
Mr. Mayor?
Alderman McMenamin.
I have a problem with, I think we can break these down into subcategories, but not I think the three ballots with initials on the side, I think that's one clear-cut category. I could see voting on those three at one time, but I'd hate to mix that issue with the affidavits issue because I think they're different, and I think we should have a vote on each of those separately. That's my opinion.
I'm sorry to say that the motion is all of them.
Okay.
Or
well, we'll take the
we take the vote, and if that doesn't work, then people can throw out whatever they want and whatever you think is going to get 6 votes. But I'm just throwing this out there because we got to do something to get this done. I feel bad for these people.
Well, if I may add, Mayor.
Judge, you're moving up, Mayor.
I just got a promotion.
There's a lot of judges here. If we mix this all together in one vote and it passes,
right.
We have to be looking down the road. We don't want to provide a easy path for litigation to either side. I think we've got to be careful by lumping too much together in one vote. And I think the issue of the affidavits, that's a different type of issue than the ballots with the initials on the side. I just would like to add, to the path that Alderman Redpath was on, why we should treat these issues differently. The way I see it, there's a lot of shalls in the state law regarding how you do an assisted voting. And I'm familiar with it. Why? Because my wife has assisted her mother, who was blind at the time. And so she became very familiar with how you do this. And so it's important that this all be done correctly. But there's all kinds of shalls to back up what Alderman Redpath was saying. And as far as the 11 affidavits from the Precinct 87, the way I understand it, none of them indicate the name of the voter who received assistance by name. None of them contain the signature of the person rendering assistance. None of them are endorsed by a Republican judge or an elected judge administering the oath. 10 of the 11 challenge affidavits contain no oath attesting to the reason assistance is needed. 10 of the 11 affidavits are not properly endorsed by the voter. And finally, 9 of the 11 affidavits do not contain the name of the person assisting the voter. So I think we have substantial noncompliance there. And so we don't want to allow our decision tonight to then go up the court system and we then end up with a court overruling the city council. And as far as Alderman Turner, I think if you're going to participate in the vote, I think it'd be appropriate for you to comment. But if you're not going to participate in the vote, then I don't think that it's appropriate to make comment because that could be judged as influencing the vote. So I think you've got to make up a decision what you're going to do tonight.
Alderwoman DeCenso.
We sat here the other night and said we were going to count all the votes. You said that, Mayor.
Correct.
So if we're going to count all the votes, let's count all the votes. None of us sitting up here live in Ward 2. This is not about us. This is about the voters, and this is about the 2 candidates. So if we're going to count all the votes, let's count all the votes.
Alderwoman Conley. Well, then we'll go back to...
Oh, I'm sorry. I was probably just...
Okay. Alderwoman Turner.
As an elected alderman, I can comment on anything that I choose to comment on. That's the first thing. The second thing is, we were here for a long time Tuesday night.
A point of order. I just think it's inappropriate.
We were here.
A point of order can be raised at any time, and I think it's inappropriate for someone who decided to recuse themselves from the vote. And a point of order, you can interrupt with a point of order, Mr. Mayor.
Corporation Counsel, will you add some instruction to this, please?
In the event of a point of order, then the chair would make a ruling on the point of order. If the objection or question is answered, primarily it would be up to the chair to make decisions on who to recognize.
Okay.
So if there's a point of order regarding recusal, then you would make a ruling on that, whether or not it's a proper point of order, and then proceed in that fashion.
Okay. Alderwoman Turner.
Thank you. And this whole issue has been discussed.
You can also interrupt to overrule the chair's opinion on this.
Oh, my goodness.
If the process is, if there's a point of order, a ruling made, then anyone can make a motion to overrule the chair's decision.
And I have no problem if you're going to vote tonight, but if you're not going to vote, I just think, because this is
You have to make a
exclusively
motion.
decided, so I'll make a motion that we overrule the chair's ruling that
Recognize
Alderman Turner can
Alderwoman
vote.
Turner.
Can
Is there a second?
discuss.
Is there a second?
Well, so you're good to go, Alderman Turner.
Thank you.
Glad I have your approval.
Just
And I'm quite sure there have been a huge number of discussions about this issue. And we came back tonight, and Alderman Hanauer is the only person that put forth the motion. So I think that we should respect his motion and Aaron Conley's second, and take a vote on it. If that motion doesn't pass, then Alderman McMenamin has every right to make an alternative motion.
Thank you.
so you're voting for.
Is there any other discussion on the motion?
I object to this procedure.
Oh, sorry, Alderman Redpath.
I would move for a 5-minute recess.
Second.
The council, by majority vote, can recess a meeting. It's a matter of just taking a vote on that motion if there's a motion to recess.
Is there a purpose? Do we have to state a purpose?
Well, that would ordinarily would be appropriate, but I don't think it's required for the purpose of just the motion.
What's the purpose, I guess?
I want a 5-minute recess.
I'll second the motion.
I already seconded it.
All in favor to recess for 5 minutes, say aye.
Aye.
Opposed, say nay. For recess for 5 minutes.
Problem with you commenting if you have I had to myself.
We're back in session, please.
We gotta try that.
To reconvene, we're discussing the amendment, the motion.
Hey, Mayor,
Corporation Counsel, if you want to clarify where we're at,
I'm sorry,
please.
go ahead.
Procedurally, the motion was made regarding the adopting the hearing officer's requirements with certain modifications, and I think that's clear. It was seconded. There was various discussion and debate. There was a motion for a brief recess, so we're now back in council session so that it is proper to continue the discussion regarding the motion.
Mayor, I call the
Alderman
question.
Hanauer,
I call the question.
Do we have to take a second to that?
Just say all in favor if they want
Of calling the question? Or just
all in favor of calling the question, and then it'll be a vote.
all in favor of the calling the question, say aye.
Aye.
No,
Opposed, say nay.
no.
The question is called. So we need to do a roll call vote?
Roll call, or if it's set up for the machine, I don't know what your,
Roll call.
okay, very good.
A roll call vote, please, on the motion to call the question.
Okay, roll call on call the question.
Okay. Alderman Redpath.
Before I vote, I want to explain my vote because
This is to call the question.
Question.
Okay, aye.
You want to
Alderman
explain
Sip-
that one?
Said to call the question?
Right, no, that's all right. She's
Alderman-
teasing you.
Don't get me
Alderwoman
upset.
Turner. Alderman Fulgenzi.
Aye.
Alderman Proctor.
Aye.
Alderwoman DeCenso.
Aye.
Alderman McMiniman.
No, because I think people should be able to explain their vote.
Alderwoman Connolly.
Aye.
Alderman Donelan.
Aye.
Alderman Henner.
Aye.
Okay,
9.
so go ahead with the vote.
Okay.
Roll call, or are we doing it?
Yeah, roll call vote.
Alderman Redpath.
Before I vote, I'm going to explain my vote, and I tell you why, because I did substantial research on the strict and substantial compliance. I think that that it's mandatory by the statute that we not consider those types of votes. But I also fall back on the advice we got from our hearing officer about all or none. And I think that's more important. And I know the intent of the voters was how they voted. But I think that in order to move this thing to the next level, which I honestly believe that a judge is going to overturn, but I'm going to vote aye.
Alderwoman Turner.
Aye.
Alderman Fulgenzi.
Aye.
Alderman Proctor.
Aye.
Alderwoman DeCenso.
Aye.
Alderman McMiniman.
I'm going to explain my vote, too. I'm glad you voted, Alderman Turner. And if you had said you were going to vote before, that would have helped. But as to the vote, because last meeting you said you were not going to vote. So it's just fair to bring that up. So at any rate, I think we do have a problem with possible litigation here. I would have liked to have asked the attorneys whether proportional reduction is mandatory or discretionary. I think that's an important question to ask from a legal point of view. We don't have that answered yet. On the hope that proportional reduction is discretionary, then I think this motion is appropriate, and that's why I'm going to vote yes. But we don't have a legal ruling on whether proportional reduction for potentially invalid ballots is, again, is mandatory or not. So I'm a yes vote on the motion.
Alderwoman Connolly.
Yes.
Alderman Donelan.
I do want to say before I vote that I want to thank Judge Mielek for his community service. He didn't have to do this, and we appreciate everything. And your report didn't help us tremendously, and we appreciate your time and work. I vote aye in the interest of the voters.
Alderman Hanauer.
Thank you. I would just like to say this, that, you know, when you look at the number of ballots that were cast versus the number of ballots that were at question, it does say a lot about the work that our judges do, and it's not an easy job. And you basically got less than 1% that we had issues with. And for the election judges out there that think that we're scrutinizing their work and everything, and it does happen, but thank you for doing the work that you do. With that, I vote aye.
Mr. Mayor, that gives 9 ayes.
The motion passes. Corporation Counsel, if you'd explain the next part of the process.
At this point, it is my understanding that the council has adopted the recommendations of the hearing officer with the stipulations or adjustments that have been made.
That's correct.
With that, it is my understanding that the parties are in agreement that that places a tie vote, and I'm looking, both counsel, I think it indicated to me during the recess.
That would also be my...
Thank you. So what that results in is a and please correct me, so if I'm misstating it, that would be a 464 to 464 vote, correct, by the parties?
That's correct.
Okay. And so the statute, the Illinois law requires or provides for that where two persons get equal number of valid votes, as in this case that's been determined by the council's decision this evening, then the persons receiving such votes that the decision shall be made by lot, by either in such a manner as a court, in this case it refers to a court, but as the council would direct, meaning city council. I think that you have an option to direct the parties to get together to resolve whatever manner that they would like to do that in, or you could ask that they make a recommendation to the council, if you prefer, to how to do that function by lot, whether it's flipping a coin, whether it's by pulling something from a hat, which I think the county has used from time to time. So right now, the next proper step would be to resolve to direct the parties on how to proceed. so we have a conclusion to the matter.
Mr. Mayor,
Is Alderman Donlin?
since we have the election authority in the room, I would like to, if I can, if it's appropriate, ask County Clerk Don Gray what is recommended and if you have a recommendation.
Sure. So Sangamon County's method of that opportunity of chance is to provide for a sack in which we place 2 ping pong balls. And each ping pong ball is attributed to one of the candidates, and a third-party person draws a ball from the bag, which essentially declares the winner.
Thank you.
You have the bag here?
I don't have it here, but I can certainly get that quite quickly if you like.
Send somebody over there and get it.
If I defer to both sides what their preference is, do you prefer the county's process, or do you prefer a different process to come up, if you come up and...
Could I confer for a moment?
Sure.
Citizens of Ward 2 demand a special election.
Here we go. If they go ahead and confer with each other.
We don't want to lose on a ping pong ball or a straw. We'd rather have another election. It wouldn't cost y'all that much money to have a runoff election. Winner take all.
Yeah, that's what they're discussing.
Y'all have the power to do that.
Did you know Doris was going to vote tonight? That wouldn't be fair to her to tell us.
She doesn't have to clear her recusals with us.
She won't declare her recusal. She's going to
vote for the motion on Tuesday.
If an alternate, it's all right, but not just common sense. It's just common sense. Yep. You can't. Fair question to answer.
She didn't think that's what they're talking about.
Yeah, I didn't see who was faster.
Say what?
You guys want us to get it? They're already on the way.
Okay. Today? Tonight? Are they going to go get them?
When the court talks, they're very happy. They're not going to litigate. Blues was going to litigate, potentially.
It's whoever they choose to want to pull it out.
Can I pull it out?
If they choose you, they'll be the one pulling it out.
I think in the past, Mayor, they've actually had another...
I can shut my eyes and touch anybody. The candidate can't pull it out.
I think you need to decide who it is who's going to draw the lot. Okay. You want me to hold the bag and you draw? All right.
Are you left holding the bag?
I'm not going to fumble that, no. Oh, I'm not going to pull it. You don't want me to pull it. So Gregory's A, Simpson's B. So, Alan? Since Gregory was first on slot on the ballot and Simpson was second, we normally attribute the first ball A being Gregory, second ball being Simpson. the second candidate.
And remind me how this goes.
So I have to remember if it's a 1 or a 2, if it's A or B. We'll see when we get it. So
We'll
there's
just need to announce that Mr. Gregory, for example, will be either A or more.
Yes.
And then,
Yep. There'll be 2 balls. They'll each be clearly identified as either A and B or 1 or 2.
Right.
And we will attribute each ball to each candidate. Okay? And then they'll select one out, and that's who it is.
right.
Yep.
Okay.
So, and
We use law enforcement?
we usually use law enforcement to
Why
draw.
don't we do that?
It's really up to you guys. Yeah. We'll always have a court security personnel person. We figure that no one's going to question the integrity of a law enforcement officer.
We have the chief of police.
I don't know if you want to go that far.
I mean, I think somebody that's not been involved in this process is what he's thinking.
Okay,
Yeah,
that's fine.
That's okay. So we'll wait to see how it is that we marked the balls. I can't remember.
No, they're the same side.
right there. He's right over there. Oh, Donald, there's a little kid out there. Oh, has to be voting
Everybody take their seats, please, with the exception of the attorneys and each party. And then Don Gray's going to explain the process, but everybody else has to take their seats. I know this is a passionate moment for everybody. Nobody wants to be in this position, but we're going to do it the democratic way. As County Clerk had stated, he stated the process and point of a tie, how that is worked on the election level, and we're going to adhere to it. So if anybody cannot do it civilly, they don't think they'll have their emotions in check, you should just kindly leave, because everybody's at that point of interest and passion for what happens. But the bottom line is, I think the council voted correctly, to show that each vote does count, and that's what this is all about. And what we should take from this, whatever's decided, we work together to make sure we energize all our community to have a greater turnout. That's what Springfield's about. That's what the energy in this room's all about. That's why I didn't have someone out of order. It's about speaking up, and I understand that, but we really need to work together to improve our community together. So we really appreciate everybody that's here in attendance and all your interest in this, but we just ask that you do it civilly. Thank you. So, Don, if you'd like to explain, Clerk Bray.
So this is the exact method in which Sangamon County has broken ties for elections before in the past. There is a bag of which you cannot see through, and there are 2 balls for each of the candidates. Being the first person on the ballot, we've attributed the first ball, and the next person thereafter the second ball.
Can you show the numbers?
I will. Yes, of course. There's the 1, just for the council, and of course the 2. See? Exactly the same ping pong balls. Gregory was first on the ballot, so he will be ball number 1. Second on the ballot was Gail Simpson. She will be ball number 2. You will see that there are no other balls or materials inside the bag. Anybody care to put their hand through it to confirm? You're all good. All right. I will now put the balls inside. Shake it up.
Turn it upside down and everything. Turn it upside down and everything. Yeah, thank you very much. Spin it around. That's good.
Spin it around, shake it, and go.
Good, good, good. And then did both sides agree that Judge would pull from there? Or what did you decide, both sides?
Mayor,
come up front here, Don, if you come up front and center.
Our preference would be to have a person that's not been involved in this process at all draw the ball. Okay. We suggest Misty Butcher.
Okay.
Busher.
Oh. Sure.
Is, or somebody back there is that okay with you guys?
Close your eyes.
Again, if we keep civility, that's what's mandatory. If anybody gets too rambunctious, we don't want to do it, but they'd be dismissed by way of one of our security officers, Springfield's finest. So we really appreciate everybody's interest. And Misty, whenever you're ready, if you want to close your eyes and draw, whatever you want to do.
I will wish luck to both of you. You're both very wonderful people, in my opinion.
Nice.
Nice.
Thanks for your help. So with that, is there any other business that we need to conduct?
Adjournment, and then we'll work on the details.
Is there a motion for adjournment?
So moved.
Second. Any discussion? All in favor, say aye. Aye. We are adjourned.
Don, thank you for your assistance and your help. I appreciate it.
Absolutely.
Yes, I was. Thank you. Yep.